knows when it's live.
So when a new idea pops into your brain, call the patent professor. That's my name. I'm a law school professor. An engineer too. I think math is fun. Patents are cool.
Good evening. Welcome to another monthly edition of Ask the Patent Professor. And those of you that have been listening for some time, our live audience, and also those on the live stream, you may remember we had a session on prototyping and had an expert on prototyping here. One of our Ask the Patent Professors focused exclusively on the different types of patents. As a review, it's utility, design, and plant patents. The two types of utility patents are provisional and non-provisional. And then we had, at one of our Ask the Patent Professor events, a former patent examiner, and we spoke exclusively about what it's like to be an examiner and what the patent search is about, and the process that we go into to determine if a patent should be filed. So today the topic is from branding to products. And we have Natalie here. And Natalie, you want to introduce yourself? She's one of our in-house trademark experts. That's what she specializes in.
Hi, I am Natalie Parcinski. I am our lead trademark attorney here at the Patent Professor. I formerly came from Harley-Davidson, working in their trademarks department, protecting all of the brands, logos, marks for Harley-Davidson. And then I've built my career from doing patents and trademarks, and now I'm here with the Patent Professor.
Cool. Terrific. And if you're here, if you're in our live stream, if you have questions, just go ahead and type them in. We have Crystal here. She's monitoring the live stream. And if you're here in the actual audience, just feel free to raise your hand, and we can address any questions throughout, perhaps maybe even during, if we get at a good point. Now, the first thing I want to start with, because as as a patent firm, intellectual property firm, we get a lot of inquiries about patents and trademarks, and I want to get the vocabulary clear at first, because we'll have requests, and Natalie gets these a lot from somebody that wants to patent a name or trademark a product. So talk to us about that. What can you patent a name?
So the name, no. With a patent, that is for the product, a device, a series of steps. With a name, you would want to get that either with a copyright or a trademark. The trademark is going to be protecting the origin of that name. And so that's where, when you've got a brand and you want to make sure when it's out in the market that people know who it came from, where it came from, that's when you want to get a trademark on it, so that people are not confused about where the originator of that product came from. And
so you can, and if you're using the term, sometimes the term patent is used synonymously with protect, and that's not really correct, because you need to say, can you patent a name? You can protect a name, but you actually do it through trademark law. So tell us a little bit, let's start with some trademark basics. Like, what is a trademark?
So a trademark is some sort of name or picture that will identify a source of a product or a service. So I think it'd be fun if we did a game in here where we empty your pockets, empty your purses, to see if anybody has a trademarked product on them right now. So if anyone wants to look in their pocket, pull something out of their purse, and see if they've got something.
Any snacks, right?
Yeah, any snacks, any items, pretty much. If there's exactly. So
we have a
volunteer.
Volunteer slipper.
So this is a great example, and we have Nike, where Nike, this is a trademarked name. Origin is Nike, the shoe company. and they create and manufacture a whole variety of different products. So Nike, absolutely one of the most famous trademarks in the world. Here you go. Anybody else have something?
Yeah, non-footwear, because of-
I see there's those yellow stickies, so adhesive tab. This, Post-its. So this is another very, very common trademark, and some would argue that this has now even become a generic trademark, which something to become generic, it's where it becomes the most common term that everybody uses it. So nobody really would call these adhesive tabs anymore. They would say Post-its, and no matter the brand, it could be from Post-it, it could be another brand from an Office Depot brand, but everyone still calls them Post-it. So unfortunately, that weakens the strength of this particular trademark. And we can get into the different types of trademarks in a few minutes. Any other items out here? Let me give that back.
And while we're looking for new items, if anybody has, and even for our live stream audience, if you have any products where you see the word brand on the product, like for example, you'll see Doritos brand tortilla chips, that's the company trying to prevent their trademark from becoming generic. So they're teaching consumers that, hey, don't call tortilla chips Doritos. They're tortilla chips, and Doritos is the brand. So,
companies will try to make sure that their trademarks stay distinct by putting maybe the generic or descriptive term on there. Where Doritos, it'll say tortilla chips. Places that maybe do lip balms really want to stress their own particular branding instead of everyone calling them chapstick, because chapstick is its own brand in and of itself, but it's become common as the lip balm that everybody knows. So a lot of those manufacturers really stress that they're lip balms and it's their particular type of lip balm that they are selling. I see someone with a coffee cup over here, and I don't know if you want to bring that to me, but Starbucks, that's a big brand, everybody knows. It has the Starbucks.
I'm gonna go grab it because I don't think we want it
that
thrown
one's
on.
a little harder to see.
Oh, here you are.
But there's, not only does it have Starbucks, the actual name on the packaging, and there's also a picture on the side, and a lot of people know the picture I'm talking about with the woman with the crown and then the fishtails on each side, and that's their logo. So it doesn't have any wording on it, but it does have a picture that everybody recognizes. And I think going back to those Nike shoes, the swoosh that everybody knows is also one of those pictures that everybody knows and can associate with Nike. And there's a lot of those types of trademarks that are popular in the world that you just become to know them, they become part of everyday life, and they're just such strong, powerful trademarks. Everyone knows where they came from. So I'll give this back to you.
And if there's anyone in our live stream that can think of other examples like the swoosh, that where the image they believe is distinct enough that identifies the company, go ahead and type that into the chat, and if Crystal sees them, she can point them out. As well as if you happen to know the Post-it example, if you can think of an alternative, like what would you ask for if you went into an office supply store and wanted those? And if you find yourself mentally searching for what else could I call it, that's a sign that the product is maybe at risk of becoming generic. These are not just, these are not products that the live stream or that our live audience has. These are a couple of things we've kept on the side. That disc, do you mind passing that over? And I'm referring to it as a disc on purpose. But this is an example. So if you're in our live stream, if you can think of, if you wanted to go into a toy store and ask for this, but not use the brand name, type in what would you call this? What would you call it?
If it weren't
and then
the F word that we're trying to avoid. So yeah, those become things that are difficult once you can't think of an alternative for them what would you call it if you were trying
Since
to
we have
refer to it?
any alternatives?
What else
from
could
our-
this be called in the audience? Anybody?
A flying disc.
A flying disc? Anything else?
Anyone have another possible term? If you went into a toy store and asked for a flying disc, would they really know what you're asking for? Maybe not. So
Yeah.
do you want to,
Plastic flying disc.
well,
Any
we can-
other suggestions?
before we reveal what the F word is.
But, yeah, so it is a flying disc
Disc golf.
on the back.
Oh.
It does say flying disc as the, kind of the generic term for it. But most commonly, people would say that this was a frisbee instead of a flying disc. But that was the original, or the trademark, when this toy became popular. And any other question or suggestion?
Someone from our live audience said disc golf.
Disc golf? Mm-hmm. So like a disc golf
Toy.
projectile?
Yeah.
Then that would be, that would be another suggested name. I think those are always fun. Another common one would be like Kleenex. If anybody, the alternative names for Kleenex. I think most everyone walks into a store and they wanna find a Kleenex, or do you have a Kleenex I can have? Are there any other names that people would call that?
Tissue.
Tissue, yeah?
And you'll see, I don't know if we have, anyone happen to have brought a box of Kleenex here, box of facial tissues, but
Facial
if you have
tissues.
one, that's one that I do recall. I believe it has the word brand written out, B-R-A-N-D, and it's the company trying to teach consumers that this is Kleenex brand facial tissues. The same way that Doritos does with Doritos brand tortilla chips. Those that remember Sanka, a brand of decaffeinated coffee, like they would always, on their commercials, say Sanka brand decaffeinated coffee. So that people do not associate that name with the product, and then the name loses distinctiveness.
Mhm.
So tell us, for those inventors that are looking for, that have a product idea for a new invention, but they also are considering branding as well, what should be their route of going forward?
Okay, so if you've got a new product and you're looking to take those steps towards protecting it in all the ways that you can, what we would suggest is that you first file an application for the patent, because the trademarks, once those are filed, it's public domain. Anybody can search and find an actual trademark application. So if there's any information related to the product, that would become part of public disclosure. So you wanna make sure that you have it protected with a patent application first before you then file the trademark application. And so that's generally the sequence of steps that we'd wanna go. Make sure that you get that patent application in there first, then you get the trademark application. Both do require a pending period, so the prosecution period where it is pending before the Patent and Trademark Office. It will be reviewed and then approved, but you wanna get that patent application in first and then file for your trademark application.
So we get a lot of questions from inventors with new ideas, and they want to get the domain name protected. And there's some confusion on whether, if they have the domain name, do they really need a trademark?
So yes, you would wanna have the trademark. The domain name's gonna just be a source for your website. Not necessarily will that be what's protected to the public. The domain name, there are domain names that can be trademarked, but that's as a source identifier. So if you're going to be consistently using your domain name as the source of how you're going to be known, then you would want to move forward with that trademark registration. But with the trademark itself for the name, that's gonna protect you as a source. Like Nike. Nike isn't known by Nike.com. They're known by Nike, their particular brand. You look at Harley Davidson, they're not known by HarleyDavidson.com. they are Harley Davidson or HD. Patent professor, not known by patentprofessor.com. It is a source identifier. The patent professor that's the name, that's where the strength is, and that's what you want to have protected so that other people can't be using it.
Now, Natalie, you pointed out patent professor as a trademark. I don't know if our audience can see the R with a circle around it. But Lenny, in fact, I'll pull this up and then we'll be able to point to it as well. But there's a lot of times confusion over this mark, if you want to point to it right there, versus a TM. So talk to us about when can you use the R with a circle around it, when can you use the TM, and what's the difference?
Mm-hmm. So a TM, that generally represents this is your trademark. It doesn't mean that it's registered. It is just what you are identifying as the trademark of your business, your service, your logo. With the circle R, that's how you indicate to the public that your trademark is actually registered and protected with the United States Patent and Trademark Office. So it's like that badge of honor that you can put on your trademark, on your logo, that you can put out to the public that yes, this is protected, and it kind of gives that unsaid warning that you should not be violating this trademark because it is registered and it will be backed by the United States Patent and Trademark Office.
So at which point should they start marking their products with that
So
TM
when you
versus the R with the circle
when you're
around it?
using it and you're starting, you can start putting the TM on it. It stands for trademark. You can start using that right away. Once you get the registration from patent that everything has been approved and that your trademark is registered, then you can put the circle R onto your trademark. So there's the difference between the two. A lot of people will put the TM once they're pending and they've filed their application, and so it kind of indicates that it's in the pending phase and they're moving forward. But the big important one that gives the warning to the public is the circle R that shows it's registered.
So if somebody's considering a name for their product, I know for when they're trying to decide whether to protect the idea itself and get a patent, we do patent searches to make sure that the idea is new. Tell us about the equivalent for trademarks.
So there is a trademark search, and what that will do, it will search on the US Patent and Trademark Office database to see if there's any similar trademarks or exact matches, anything that could cause conflict or a rejection by an examiner at the Patent and Trademark Office. So we'll look through the entire database to see, like I said, if it's directly conflicting and therefore would prevent registration. If it's similar, which they call it a likelihood of confusion, that would cause an examiner to reject the application. So we'll take a look at that and give you our input on whether or not you should modify the mark or if it could be conflicting as far as being given a rejection of likelihood of confusion. Likelihood of confusion is one of the popular rejections because what they want to make sure at the Patent and Trademark Office is that your trademark is not going to be confused with somebody else, where someone of the general public won't see one trademark and then they'll see another and they're not quite sure where the origin came from. And that's what we call a likelihood of confusion. If a consumer would be confused by where the origin is, that's the essential basis of trademark protection, is to know who it came from, where it came from. So that's what we would do an analysis of when we do a trademark search, so that you know the best path forward and if anything needs to be changed or modified before you file for the application.
So, and speaking of like doing the search and identifying the manufacturer of the product, a lot of times you'll see a lot of brands that are kind of like a play on words of an existing trademark.
Mhm.
And we have some fun examples here, and let's get this one. One of these can be thrown, the other probably not. Oops. So here we have, and we'll talk about likelihood of confusion as well, because I don't know how much detail our live stream audience is going to be able to see, but these do look somewhat similar.
Mhm.
And then there's,
So this would be something like we have Jack Daniel's, again, another very famous trademark. Even the logo, the look of the logo on the front, and even the shape of the bottle. These are all trademarked features and trademarks of Jack Daniel's. We have the squeaky toy, which it's a dog toy, which looks pretty similar to the Jack Daniel's. They're saying it's what? Bad Spaniels? But it does look very similar with not only the sound of the name, the look of the logo, and the shape of the bottle. So at first glance, I would associate it with being Jack Daniel's. I would think this would be pretty confusing as far as like the origin. If I was just looking at it quickly to say, okay, they look pretty similar, this likely wouldn't get a trademark registration. But there's another aspect to it. When some of these brands, like with the dog toy, they'll do it to kind of poke fun or to be comical with a popular brand. So with this one, with the Bad Spaniels, they're purposely playing on the Jack Daniel's name, the look, everything about it. And so what that's termed in like the trademark area is parody. When you're purposely invoking the famous mark to create something that's like funny or poking fun at the original.
And it's somehow, the basis is free speech, right?
Mhm.
That this is, yes, it's a commercial product, but in a way, the argument is that by restricting this, you're restricting free speech, and that consumers really are not that confused, and that's what the argument's based on. There's another fun one that we have. Oh, let's leave it here.
Okay.
But that purse-looking thing. Yep.
Oh, nice.
Oh, you have, and a real purse.
So we
We'll
have
talk about the two.
Similar.
Different sizes, but similar
Yep.
branding. So
Mhm.
why don't you take?
So we have here famous purse brand with the Louis Vuitton. It has the LV, which is one of their logos, and very famous, well-known trademarks. And similarly, there's
Another dog toy, right?
another dog toy, but this one is the Chewy Vuitton, and it has little emblems on it trying to invoke the original Louis Vuitton, but with CVs instead of LVs all over it. So seems to be the dog toys love to do the
It's a
parody.
But the takeaway from this is these are extremely tricky, time-consuming analysis that has to be done. So if you do want to make fun of a famous trademark, just tread carefully. Make sure you get an opinion from a trademark attorney, because if Louis Vuitton tries to go after you, it's going to be an expensive battle. And if you're a small startup or an individual inventor, you need to conserve your startup cash for marketing, for sales, for potentially licensing. You don't want to get into a big battle. But if you do find a name that you think is just too good to pass up, get an opinion, because you may have a good chance of still proceeding. So make sure you get that. One thing we have not really touched upon is timeline and how long things take to protect. So how long does the trademark search take? How long does the trademark filing take? You want to talk about that?
Absolutely. So generally, it takes about 5 to 7 business days for us to return a trademark search. And after the search is performed, you'll have a consultation with a trademark attorney to go over anything that was found that was conflicting, or if it was just given that straight green light to move forward towards registration, if there was modifications needed, anything like that that came up during the search. Once the search is performed, it takes about a week, 2 weeks to prepare the application. So it's pretty quick turnaround to then move forward with the application. Once the application is filed, it is a little bit of a waiting game from there. It takes approximately 6 to 8 months to hear back from the Patent and Trademark Office for any sort of response. So there is some patience that is requested after the application is filed, but within, generally we say about a year, the application should move forward with registration.
Okay, so talk to us a little bit about protecting a trademark internationally.
Okay, so when filed with the Patent and Trademark Office, that will protect you for the United States. There are ways that you could then file internationally, and that's through the Madrid Protocol. And it is a treaty of other countries that you can file your application, and it will be then filed into those specific countries' trademark offices. And from there, it also goes through a pending period where it will be reviewed, and then either any sort of questions will come back. It could, and during the pending phase, all of that will be handled. And then hopefully it then moves forward towards registration, and then it will be protected in that specific country. But there is a way to file one application and then it's distributed to other countries so that there are international protections for your trademark.
Okay, terrific. These are all, oh, there, okay. If there's also any questions, let us know. Feel free to raise your hand, or if you're in the live stream, you can type them into the chat, and Crystal will address them. We talked about a couple trademarks that clearly have been around for a long time, like Jack Daniels, maybe
Harley Davidson.
Harley Davidson, maybe Jack Daniels maybe 100 years. Coca-Cola's been around forever, but then you hear about trademarks expiring. So there's some confusion on how do they expire. If a trademark like Coca-Cola can be around for so long, why are other trademarks expiring?
So essentially a trademark can keep going, like Coca-Cola, but you have to make sure that you're maintaining it. So every 10 years, the Trademark Office reaches out to Coca-Cola and they'll ask them to provide a specimen that they're still using it, some sort of proof that it's still in use and in the marketplace. And so it then, once they provide that specimen, the 10-year clock starts again. When a trademark expires, it could mean that the original owner stopped using it, they're no longer in business, they're no longer using that trademark, maybe they changed to something else, and so then it becomes an expired trademark. There's sometimes confusion on whether an expired trademark can be used by someone else, and it can if there was a name out there and you did a trademark search and you find out that it's a dead mark, but you want to continue to use it, then you can use it, but there's a caveat, whether or not the original owner is still using it. So that's something that a trademark search can help to identify when we look into dead marks and then searching to see if that original owner is still using that particular mark. Questions?
Yes.
Are fonts part of the trademark, for example, the patent and patent professor?
So they can be, yes. So that brings up the topic between like a word mark or a logo. So the word mark, like it says, it is just the words that are on the page, and that can be protected by itself. Then you get into a design mark, which is the logo. And if there's like a particular font or a way that a trademark is written, then that would be the logo for that trademark. So not necessarily as a logo, a picture, but it could also be a fanciful way that it's written, and that's also protectable. Any other questions?
So there is one longer question about a boxed game, and Crystal, I don't know if we have time to address it. If not, we can always,
I have another question.
oh, okay. Another one.
How would a car company file to renew a trademark? For example, Toyota renewed the Supra name before the 5th generation was brought to market.
So how would a car company renew theirs?
Yes.
So
File
if
to
there's two different ways that a trademark can be filed. And it can be filed as use-based, where upon filing, you're showing how you're actually using the trademark. Or it can be intent to use, to where you don't have it ready yet and you're not using it yet, but you intend to use it by the time it's registered. So those are two different ways that you can file a trademark. With something like the cars and Toyota registering, they may have filed for that trademark with intent to use, knowing that they were going to come out with that next car within the next 2-3 years, so then they can move forward with registration. Other questions?
Okay,
the audience?
if there's no more other questions, we're almost out of time. Crystal, it sounds like
One more?
we have one more. This will be the last question, and then, because we do promise all our attendees that we'll keep these to half an hour. But go ahead, Crystal.
So one of our live audience created a game that they've been selling since October 2022, and it comes with directions. No fancy fonts, colors, or artwork, but they were recently told that they could only get a trademark if they made significant changes or added to the directions, because it was now under fair public use. As many people do, they feel that their game is the answer. She doesn't want large companies taking her idea and making more money from her idea. How can they get the most coverage for the game to prevent their idea from large educational companies? And then there's 3 other questions, but we can go one by one.
Wow.
Wait,
That
wait,
hits on every single IP I think that we do. So with a game like that, and they're getting advice that it's now like public use, I would clarify, with the trademark, they can still move forward with the trademark. Their public use does not bar trademark registration or filing for that trademark. Even if you've been using a trademark for years, you can still move to apply for a trademark and registering it. It sounds like there may be some confusion on trademarks versus copyrights or trademarks versus patents. In the patent realm, there is a bar of public disclosure where you must file for a patent application within a year.
Right. And it's funny, you say there's confusion between trademarks and patents in this question, but I also heard fair use, and fair use is a copyright defense, typically. So I just, for this particular question, and actually this goes for anybody in our live stream audience, and certainly those that are here, we're gonna stick around afterwards as well. But if you have questions for us, if you're here live, we're gonna stick around to answer them. But even if you're a live stream, call our office and you can schedule a consultation, and particularly the person with the box educational toy, like call our office, schedule a consultation with Natalie, and she will go over the other questions you have and walk you through the process. Do we need a search, and what the next steps are? So with that, I want to thank everybody that's here in person, certainly anyone that's on the live stream, and keep watching our Facebook group, the Inventors Mastermind, and we will be you're following us on Instagram or TikTok, anywhere. Keep an eye out for the next monthly Ask the Patent Professor. And if you have some ideas for topics or something that you're burning questions on, go ahead and send those in. We use that to help determine what the next topic's gonna be. That's how we focused on searches, and then types of patents, and this time trademarks. We're getting a lot of questions on trademarks. And then prototypes as well. So if there's other areas of bringing an idea to market that you want to know about, send us your suggestions, and you will, if there's enough interest, you'll certainly see an Ask the Patent Professor series on that topic. With that, thank you everybody for being here and participating, and keep inventing.